case to come before the court is William Joseph versus Teresa Joseph. Each party will have 15 minutes to present its arguments. The appellant may reserve up to 5 minutes for rebuttal. If you wish to reserve some time when you take the podium, just let me know how much. I'll do my best to monitor the clock for you. The arguments are being visually and audibly recorded to be posted online, so please keep your voice up.
I'm sorry.
That's okay. So let's get situated. And remain behind the podium. You should not use the names of any children, minors in this matter. We have read your briefs and we are ready to proceed when you are.
Thank you. Good morning, Your Honors. Steve Bailey for Teresa Joseph. I would reserve 2 minutes. There are two issues before you in this appeal. The first one is that despite the fact that the trial court indicated it was upholding the magistrate's decision, it in fact did not do that. It upheld and modified the magistrate's decision. The modification being one that was not requested or contemplated by the parties and therefore not addressed at the trial of the matter. It is our position that Teresa Joseph's due process rights were thereby interfered with as the modification that the court made to the magistrate's decision affected Teresa's property rights adversely, and there was no hearing on that issue, simply because it wasn't before the court. In addition to that, with due respect to the trial court, it got it wrong. The issue here was what to do about Mr. Joseph's failure to pay mortgage and taxes as he was required in a divorce decree. And as a result of him not paying the mortgage, the house went into foreclosure. As a result of the house going into foreclosure, Teresa Joseph was thrown into bankruptcy. Ultimately, she couldn't make her Chapter 13 payments because she also wasn't receiving spousal support. And so the house, when she was thrown, she was removed from bankruptcy, and the house went back on the block in the foreclosure. When Mrs. Joseph was faced with the very difficult proposition of having her home sold out from under her in foreclosure, she exercised her right of redemption. Now, she did that with funds that had been granted to her by the divorce court as her separate property. Now, what had happened was she was supposed to get a share of Mr. Joseph's STRS pension, but before the division of property orders went on to secure that, he withdrew all the money from STRS. So consequently, there was action in the domestic court, and it was determined that I think $98,800 from STRS was to be given to her, as opposed to the lifetime payments that she should have gotten had he not done that. So now she's got $98,800 as her sole retirement benefit of any kind. When the house is sold in foreclosure, her right of redemption costs her that same $98,000 because she had to pay all of the mortgage back, and of course there was accumulated taxes of $35,000.
Counsel, I guess the trial court made a point of saying, I'm not using the words exactly, but that it's clear that she wanted to stay in the house. Yes. By exercising the right of redemption. If that were the case, Wouldn't that have involved a buyout anyway at some point?
Yeah, yes, Your Honor.
50%
It-
minus the 11,000?
Yes, Your Honor, it absolutely would. The problem is that no one knows what that math is, because there was no hearing on this issue. And the position that the court took was, well, when she paid off that mortgage, she increased his equity as well as hers. Well, the problem is with that analysis is, number one, we don't know what the value of the house was, because that wasn't an issue, so nobody put on any evidence. We don't know whether the payment of the property taxes increased equity or not, because we don't know if there was enough equity in the house to even increase it by paying the property taxes. And most importantly, all the money she used was her separate property. She wasn't using marital money to redeem that house. She was using her own separate property that had been given to her out of the STRS account. So that was all her money. And none of these issues were presented to the court because this wasn't before the court. The magistrate didn't make these decisions after her hearing. The court reached out and made this decision upon objections to the magistrate's decision without having ever said to anyone, yeah, I'm going to go and I'm going to consider this issue too, by the way. Or saying to anyone, do you have any evidence on this issue over here? Because I'm going to decide that too. So none of this evidence was ever presented to the court. It would have been virtually impossible for the court to do the math correctly because there was no basis for knowing this. And because it does adversely affect Teresa's property rights, it's a violation of due process. She has right before she's deprived of due property by a court, deprived of property by a court. She has a right to notice and to be heard. And that didn't happen. And the court was wrong in its analysis too. The second issue was the one that was coming to this court ultimately, even if the court hadn't overstepped on the magistrate's decision. And that is the issue of contempt. Look, as I put in my brief, there just isn't a question that Teresa presented a prima facie case of contempt. There was a court order to pay mortgage and taxes. It wasn't followed until the house sold. It wasn't followed. That's a prima facie case of contempt. Now, at that point, the burden shifts to the contemner, alleged contemner, to come forward with a defense. And really, the only defense is impossibility of performance. That didn't happen. Mr. Joseph didn't come forward with that defense. The court chose to not hold him in contempt in the magistrate's decision because of, quote, the circumstances of this case. And that's all the explanation she gave. That's all the explanation she gave. The trial court, in upholding the magistrate's decision, went a little further and said, well, the mortgage doesn't exist anymore. And so the purpose of contempt no longer exists. Which, by the way, I haven't found any case that said that's a defense to contempt. But the problem with the magistrate's reasoning is that there wasn't any. The problem with the trial court's reasoning is that the trial court was viewing this as making him paying the mortgage being the only potential purge. And we do not believe that's true. As I've outlined in my brief, the only limitation I could find on purge orders in Ohio is that they must be reasonable and not impossible to perform. There were a multitude of potential purge opportunities if he were held in contempt. He could have been required to pay her the equity that, in order to keep out of jail as a purge order, make payments to her on the equity that he deprived her of by not making the mortgage payments for 5 years. Could have been required to make payments to her on the accumulated back taxes that she ended up having to use her pension money to pay. Could have made a condition of his not serving jail time for contempt, that he quit claiming the house to her, and waive all future claims. I can find no law that would indicate that those purge orders wouldn't have been appropriate. Certainly they're reasonable under the circumstances that Mr. Joseph created, and they're not impossible to perform.
Counsel, I'm not sure I completely understood everybody's position on this in regard to this issue. The court was saying, I think in its journal entry, that it basically felt that it didn't have the authority, I hate to use the word jurisdiction, but the authority to really act, because it would be involving with the contempt purging, like you're suggesting, it would be more involving the sale of property, and it didn't, it couldn't be involved in that. It didn't have the jurisdiction to.
Candidly, Your Honor, I didn't read her decision that way, but I understand what you're saying. I would just disagree with it. Yes, the court cannot alter the property division. Yes. Although I will point out that in the journal entry in this case, the court did reserve jurisdiction over the sale of the property, although it did not over the distribution of proceeds. So, yes, the court cannot alter property division, but that's not what we're talking about. We're talking about a purge in a coercive, civil contempt is coercive in nature. So, you go to jail unless you do this. And typically, the less you do this is what you were held in contempt for. You didn't pay your child support. So, you go to jail unless you pay your child support every single month, plus some extra on the arrearage. These are typical purge orders. But there's nothing in the law that says that's the only purge order. And because he created a situation where the house went into foreclosure, Teresa had to file bankruptcy. She couldn't stay in bankruptcy because he wasn't paying the support, so she couldn't make her Chapter 13 payments.
Anything that's being said.
You can have your say when it's your time. Go ahead.
She couldn't make her Chapter 13 payments, so she was thrown out of bankruptcy. And then the house went back into foreclosure to be sold. Since he created all of that situation by his contemptuous action, any purge that would make that right is reasonable, and of course it has to be possible to perform. So a certain amount of equity would have been created in that house had he paid all his mortgage payments he was supposed to pay and pay the taxes. That could be quantified at a hearing, and he could be ordered to reimburse Teresa for that as a purge to the contempt. I believe he could also be forced to quit claiming the property as a purge. That's not a modification of property division. It's not, Your Honor. It's do this or go to jail. You don't have to do it, but then you're going to go to jail. And therein lies the distinction. So to say you can escape punishment's not the right word. You can escape the onus of contempt if you don't do something for long enough so that in this case, don't pay house payments long enough so the house goes into foreclosure, is sold a foreclosure sale, someone has to redeem it out, so therefore there's no longer a mortgage, and therefore you've somehow cleansed yourself of the contempt of not paying the mortgage. I think it's a very, very bad precedent. Okay?
Mr. Joseph? You will now have 15 minutes to object to whatever you like to object to.
Okay, well, with the issue of what Mr. Bailey was just addressing, quite simply, both the magistrate and the judge said I was not in contempt of court for not paying the mortgage. Therefore, the court did not consider any possible purge situations because I was not guilty. And they said that based on the magistrate specifically used the language due to the evidence submitted. The judge said after reviewing the transcripts of the proceedings and the exhibits presented at trial, the judge had reasons for making her decision, as did the magistrate. Now, they may not agree with those decisions, but the judge and the magistrate had their reasons. They were within the law. He has presented no case law or really facts as to why the judge's decision should be overruled. So again, the judge didn't consider purge actions because there was nothing to purge. I was not guilty of contempt of court. And I guess I've been so upset by this process, both in my brief and in my statements. Right now, I have a document from the Office of Disciplinary Counsel from the Supreme Court. And one of the things that is stated is that...
Hang on for a second. Is that part of the record below at the trial court?
No.
You can't consider it. I'm sorry.
Okay.
It's not something
Well, I will just say that this brief is full of inaccurate information. There are lies, outright lies in here, and he's not supposed to be misrepresenting information or telling lies to the court. And that is something I am going to address formally.
I wanted to say something too, that, we get this from both sides, allegations of that nature all the time. Bear in mind that we go through the record with a fine-tooth comb, and if something is not there, it doesn't matter what anybody says in their brief. And if the law is not that, it doesn't matter what anybody says in their brief.
Okay.
So I just want you to know that.
I appreciate that, because there were statements that I stole money, and there's never been any proof presented that I've stolen money, so it's just been kind of upsetting. And I guess on the first point, the assignment of error 1, I'm not sure exactly why Mr. Bailey and Teresa are upset about that. Now, they filed a motion for compensation originally, and through the judge's motion, they were granted an extra $49,900. Now, Mr. Bailey's saying that adversely affected Teresa's, what she's due from the sale of the house, but she was granted an extra $49,000, so it really affected how much money I get from the sale of the house. So I'm not sure why he's objecting. I should be the one objecting, but I'm not, because it's a complicated case, and I'll just chalk that up to the judge making the best decision she could under the circumstances. But again, he didn't present any legal case or justification of why the judge's ruling should be overruled on either issue, and his assignment of error 1 or assignment of error 2. And it's in the court records that I contacted STRS. I was within my legal right to take the pension money out of the STRS fund, and in fact, she received $99,000, I received $69,000 of that money, so she got more money than I did. She had that money in the bank. She could have used those funds to be paying the mortgage and be paying the taxes. She chose not to. So I didn't force bankruptcy. I didn't force the house into foreclosure. As you stated, the magistrate found that it was Teresa's intention to remain in the house.
If you know, and if you don't, that's fine, I don't expect you to, but the pension distribution that you've just referred to,
Yes.
do you know when in the course of time that occurred? If not,
2009, 2010.
okay, thank you.
I mean, the money
We'll
was
check the
in,
record, but,
the money was in the bank before the foreclosure happened, so she chose not to use any of her funds to pay that. And the argument about the sole property, I mean, all the mortgage payments I made were my sole property. They weren't joint accounts, so to my mind, the court treated her funds the same way they treated mine. I used my money to pay the mortgage when I was paying mortgage payments. She used her sole property, $98,000, to pay the house when she paid it, but I don't understand why that's a problem. And again, there's no legal precedent that was cited why that should be an issue in the judge's decision. And Mr. Bailey's argument is kind of summed up by the statements about my contemptuous behavior causing the foreclosure and causing the sheriff's sale. He talks about the entire chain of events caused by my contemptuous behavior again. The magistrate and the judge both ruled based on the evidence that were presented in this trial, because he said in his brief that I didn't present any evidence to the court, but I did. And that's what the magistrate and the judge used to base their decision on. It's a complicated case. You know, honestly, we were both wrong. We both did things we shouldn't have done, but those joined together, both of our misdeeds, to cause the whole thing, not just me. And I wasn't found in contempt of court, therefore there was nothing for the court to consider possible purges and everything. Mr. Bailey mentioned about me making payments, me going to jail until payments were made. That didn't matter. The judge didn't consider those at all because I wasn't guilty of contempt.
any questions? Thank you.
Thank you. Just real quick, I never said he didn't present evidence. I said that he didn't present a defense of impossibility, which he did not. You know, Mr. Joseph had an interesting point, a really interesting point, I think, that the court treated his separate money the same as you treat Teresa's. The difference is Teresa wasn't ordered to make those payments, and he was. And that's a critical difference. And yeah, I guess I can't remember the timing exactly, but at least a little while before her bankruptcy, she probably chose not to use those funds to pay the mortgage, but she wasn't supposed to have to pay the mortgage, and those were all the funds she had for her life, for her retirement. And one real quick aside, because he mentioned that she got more than he did. Well, yes, she did, because as this court, I'm sure, understands, when you withdraw your money from a public pension, all you get back is what you put in. The value of the public pension is many times what you've put in. And so instead of letting that come in monthly payments to Teresa for the rest of her life, which had big value, he took all the money out of STRS that cut her off from those monthly payments, and therefore, when the court accorded a portion between them, that money, it gave her more because his action had shorted.
All right,
Thank you.
thank you.
Is there time for me to?
Yeah.
The
The appellant is afforded the rebuttal time. All right, thank you both for your briefs and your arguments. We will take the matter under advisement. We will issue a written opinion in due course. It will be mailed to both sides and posted on our website and that of the Supreme Court. Thank you.
Thank you.